So, I talked the other day about this bill going through the state of New York, Assembly Bill a416. And as I say, if you want to know about something, go to the source, read, learn, study, educate yourself. Don't rely on other people to do it for you. Don't rely on me to do things for you. Even though I am showing you the website right here, which you can go to yourself so that you can follow this bill. Okay, and I do not live in the state of New York. But why do I have concern about this? Well, because ideas spread. And if I let shitty ideas affect other people without saying anything, then what can I say when it comes and bothers me? Except what everybody else says. Oh, I don't like it now because it affects me negatively. Mwah! Yeah, that's not how life works. So, as you can see, it's in committee right now, which means it's not the final bill. We can critique, comment, express thoughts. Pretty sure I just said that, but I screwed up on my previous recording, so I'm recording again. And I like to do shit in all one take, which means sometimes things slip through because there's only so much I want to do. But anyways, let me point out that I am not a lawyer. But you do not need to be a lawyer in order to read law, because look at that, it's written in English. Who would have fucking thought? Although if you are interested in law, then you should probably start reading legislation, particularly famous cases that you've heard about through history. You know, like Roe versus Wade, Jacobson, and so forth, because they're kind of important right now. Citizens United. Read the transcripts, read the decisions. Read different pieces of legislation, like the CARES Act, because that's only like 1 or 2 pages. Take you about 5 minutes, I'm sure. Yeah. But seriously, to study something, you have to look into it from multiple angles. If you want to study a subject, buy multiple books. If you want to study law, read multiple laws. Maybe it'll be something you become interested in, and then you too can become a lawyer and potentially fight for somebody's rights. Or fight to screw over people, you know. Some people, there's always that thing about lawyers and, you know. Yeah, I won't get into it. So, let's read this. An act to amend the public health law in relation to the removal of cases, contacts, and carriers of communicable diseases who are potentially dangerous to the public health. Okay. Not retaliation, relation. And realistically, this is me reading and you're following along, listening to the sound of my voice, which I don't know about you, but to me sounds like nails on chalkboard, but whatever. The people of the state of New York, represented in Senate and Assembly, do enact as follows. Section 1. The public health law is amended by adding a new section 2120 Tech Alpha to read as follows. Why is this not capitalized and that is capitalized? I'm not too familiar with New York state law, so it might be just something along those lines. You know, just like every state does things differently and they have their own little quirks about how they write their laws. Okay, 2120 Tech Alpha. Removal and detention of cases, contacts, and carriers who are or may be a danger to public health. Other orders. Now, we'll keep in mind that this is still in the committee page, but other orders, that's a really vague. It's probably a placeholder. But we'll make note that that's there. 1. The provisions of this section shall be utilized in the event that the governor declares a state of health emergency due to an epidemic of any communicable disease. Okay? So at least it's an epidemic. Hopefully somewhere in this legislation or some relevant legislation we have defined what an epidemic is, but we will continue. Upon determining by clear and convincing evidence that the health of others is or may be endangered by a case, contact, or carrier, or suspected case, contact, or carrier of a contagious disease that, in the opinion of the governor, after consultation with the commissioner, may pose an imminent and significant threat to the public health resulting in severe morbidity or high mortality, the governor or his or her delegee, including but not limited to the commissioner or heads of local health departments, may order the removal and or detention of such a person or a group of such persons by issuing a single order identifying such persons either by name or by a reasonably specific description of the individuals or group being detained. Black people! Yeah, okay. So, that's one problem. Is that's kind of allowing for that. So realistically, they're saying, hey, we can say that there's a health problem here, so we can just make an order to detain a group of people. Now, it has this text up here, back at the beginning of the sentence, clear and convincing evidence. What is clear and convincing evidence? Is this clear and convincing evidence to the quote-unquote reasonable person, which in the case of an epidemic would probably not be so reasonable if it were an actual epidemic? Okay, so these are little things we have to ask when we see text like this. What do we define a contagious disease? What do we define severe morbidity or high mortality? How do we define these things? These are things that people like to have numbers to. All these words in here, in this entire sentence, many things are highly subjective. And this is a problem in law. Let us continue. Such a person or group of persons shall be detained in a medical facility or other appropriate facility or premises designated by the governor or his or her delegee and complying with subdivision 5 of this section. Now keep in mind that this is... Oh, I got you a few more lines. There we go. This is part of a bigger thing, so that subdivision 5, let's look down. Okay, it's probably that part down there. Okay. Okay, number 3, a person or group removed or detained by order of the governor or his or her delegee pursuant to subdivision 2 of this section shall be detained for such period in such manner as the department may direct in accordance with this section. Okay, that's just legal speak for, hey, you know what, we can decide to do this and we're going to decide how to do it. And as long as it doesn't break the rules of what we have here, we can do it. 4, notwithstanding any inconsistent provision of this section, Alpha, a confirmed case or carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines that such person is no longer contagious. Bravo, a suspected case or suspected carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines with the exercise of due diligence that such person is not infected with or has not been exposed to such a disease, or if infected with or exposed to such a disease, no longer is or will become contagious. Okay, so what exactly is the exercise of due diligence? That is a very vague term. And again, we go back to the mythical reasonable person. Well, this is very subjective text. Is due diligence, you know, he's kind of groggy, and I know he said he didn't sleep right last night, but I think the fact that he's kind of groggy is enough to keep him here. Let's move on. Charlie, a person who is detained pursuant to subdivision 2 of this section as a contact of a confirmed case or a carrier shall not continue to be detained after the department determines that the person is not infected with the disease or that such contact no longer presents a potential danger to the health of others. Well, how long is it going to take for the department to determine that the person is not infected with the disease or or that such contact, blah 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 blah? Because, you know, even if you're for this legislation, this part right here leaves things pretty wide open. So what? Hey, we have evidence that you might be a carrier of a disease, so we're gonna lock you up for a while, and yeah, we'll get around to making sure that you don't have the disease. I mean, I know it typically only lasts within people for like what, 5 or 6 days, and you've been here for 7 months, but you know we'll I assure you that we'll get to it. We're following the law. But let's keep reading because you never know. Some of these things might be addressed later. Delta, a person who is detained pursuant to subdivision 2 of this section as a contact of a suspected case shall not continue to be detained. Roman numeral 1, after the department determines with the exercise of that mystical due diligence again, that the suspected case was not infected with such a disease, or was not contagious at the time the contact was exposed to such an individual, or Roman numeral 2, after the department determines that the contact no longer presents a potential danger to the health of others. Presents a potential danger to the health of others in what sense? Vague terminology. A lot of vague terminology. Now, sometimes vague terminology is just a lack of foresight. And that's understandable because we're all human. But again, this is why we look at these things and point them out. So we have the mythical standard, a subjective standard of due diligence. We have no time period on departmental determination. Now, this shouldn't probably not be so here's where the problem comes when writing a law and determining these things, because, well, I can say a hard date after the beginning of detention from which the department must make a determination, do tests and do determinations. But then there's the situation that a test may take longer because of new technologies, new strains, and so forth. So how do you write something that accounts for both of those things? I've got some ideas, but I'll let you think about it. Number 5, a person who is detained pursuant to subdivision 2 of this section shall, as is appropriate to the circumstances, subjective text, Alpha, have his or her medical condition needs assessed and addressed on a regular basis. Okay. Now this is better. Okay, this is addressing some of the things I talked about before, but we're still in vague territory. What is a regular basis? Okay. And bravo, be detained in a manner that is consistent with recognized isolation and infection control principles in order to minimize the likelihood of transmission of infection to such person and to others. Okay? So we still have some vagueness going on in here. 6. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period not exceeding 3 business days, such person or member of such group shall, upon request, be afforded an opportunity to be heard. Okay. So, looks like we're starting to address some issues. It's good. Now, realize that, I don't know if you picked up on it already. Actually, I pointed out before when I was talking about subdivision 5, and as look later, here it's talking about subdivision 2, which means earlier in the same text. So if you need to read that again, go ahead and read that again. Just wanted to, point that out again. So we have 3 business days upon request. Good. If a person or group detained pursuant to subdivision 2 of this section needs to be detained beyond 3 business days, they shall be provided with an additional commissioner's order pursuant to subdivisions 2 and 8 of this section. So 2 we've read already, and 8 we have not. Okay. So this is good. It addresses things that I already brought up, and this is how you want to read really anything, not just law, right? This is called active reading. As soon as you read something, you start picking out things and start asking questions. And you think to yourself, well, does this thing answer it here, or is it going to answer later? I should probably remember this question because this is something I want to know. Okay, number 7. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period exceeding 3 business days, and such person or member of such group requests release, the governor or his or her delegee shall make an application for a court order authorizing such detention within 3 business days after such request by the end of the first business day allowing such Saturday, Sunday, or legal holiday, which application shall include a request for expedited hearing. After any such request for release, detention shall not continue for more than 5 business days in the absence of a court order authorizing detention. Notwithstanding the foregoing provisions, in no event shall any person be detained for more than 60 days without a court order authorizing such detention. Okay, this is a lot of good text. Okay, so you have the 3 business days for your request. And unless there's a court order saying to hold them for 5 business days, you gotta get like 5 more business days, or up to 5 more business days. Gotta be let go. And no matter what, you can't be withheld for more than 60 days. Okay. The governor or his or her delegee shall seek further court review of such detention within 90 days following the initial court order authorizing detention, and thereafter within 90 days of each subsequent court review. In any court proceeding to enforce an order of the governor or his or her delegee for the removal or detention of a person or group issued pursuant to this subdivision for review of the continued detention of a person or group, the governor or his or her delegee shall prove the particularized circumstances constituting the necessity for such detention by clear and convincing evidence. Okay, so once again, the text has gotten a lot better here. It's providing us with more objective information, less subjective. However, we still have this part here. Showing a necessity by clear and convincing evidence. Okay, that's primarily objective language. Okay, so basically it means you can't hold somebody unless you actually show there's a need, and you have to show that need in a way that is, you can just look at it and say, yep, okay. Number 8. Alpha, a copy of any detention order of the governor or his or her delegee issued pursuant to subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it is impractical to provide individual copies, it may be posted in a conspicuous place in the detention premises. Any detention order of the commission issued pursuant to subdivision 2 of this section shall set forth. Roman numeral 1, the purpose of the detention and the legal authority under which the order is issued, including the particular sections of this article or other law or regulation. Roman numeral 2, a description of the circumstances and or behavior of the detained person or group constituting the basis for the issuance of the order. Roman numeral 3, the less restrictive alternatives that were attempted and were unsuccessful, and or less restrictive alternatives that were considered and rejected, and the reasons such alternatives were rejected. Roman numeral 4, notice advising the person or group being detained that they have a right to request release from detention, and including instructions on how such request shall be made. Roman numeral 5, notice advising the person or group being detained that they have a right to be represented by legal counsel and that upon request of such person or group, access to the counsel will be facilitated to the extent feasible under the circumstances. And Roman numeral 6, notice advising the person or group being detained that they may supply the addresses and or telephone numbers of friends and or relatives to receive notification of the person's detention, and that the department shall, at the detained person's request and to the extent feasible, provide notice to a reasonable number of such people that the person is being detained. So, what is this section all about? It's all about telling everybody everything. This is all about transparency, pretty much. Saying, we got to let you know why we're doing this. We got to let you know what the evidence was against, or not against you. The evidence was that we decided to take this action. We have to let everybody that you want us to know within reason. Okay? So basically not making people just disappear and not knowing what the fuck is going on. So, okay, at a first glance, this all seems pretty fair in that respect. Okay, bravo. In addition, an order issued pursuant to subdivisions 2 and 7 of this section requiring detention of a person or group for a period exceeding 3 business days shall, Roman numeral 1, advise the person or group being detained that the detention shall not continue for more than 5 business days after a request for release has been made in the absence of a court order authorizing such detention. Roman numeral 2, advise the person or group being detained that, whether or not they request release from detention, the governor or his or her delegee must obtain a court order authorizing detention within 60 days following the commencement of detention, and thereafter must further seek court review of the detention within 90 days of such court order and within 90 days of each subsequent court review. And Roman numeral 3, advise the person or group being detained that they have the right to request that legal counsel be provided, that upon such request, counsel shall be provided if and to the extent possible under the circumstances, and that if counsel is so provided, that such counsel will be notified that the person or group has requested legal representation. Okay, so the way this legislation is reading so far is that it's basically handling a person that it considers that the governing body, the governor of New York, the way that they approach it as if someone has, it's similar to the way someone's committed a crime. So when somebody commits a crime, there's evidence that's found, and you get an arrest warrant, right? As if it's not, happening on the spot. So if you commit a crime, they have they get an arrest warrant, and then they arrest you. You're in jail, and then you go for a bail hearing, and then you fight out your case in court. So what this legislation seems to be doing so far is making this process similar to that, where you go they come across evidence. You might have some disease that they consider to have a high morbidity or high mortality. So they'll come, grab you with a similar procedure, and getting court order. Right, court order requires Actually, I don't recall reading that a court order requires initial seizure of a person. So that's yeah, but if somebody, warrant is issued by a court, right? I don't know. I'm half asleep right now. Shut up. Yeah. So, but it's basically so far like the same way of committing a crime. But the crime, quote unquote crime in this case, is you're sick with something. And for now, let's continue reading. Number 9, a person who is detained in a medical facility or other appropriate facility or premises shall not conduct himself or herself in a disorderly manner and shall not leave or attempt to leave such facility or premises until he or she is discharged pursuant to this section. Don't break out of sick jail. Number 10, where necessary and feasible under the circumstances, language interpreters and persons skilled in communicating with vision and hearing impaired individuals shall be provided. 11. The provisions of this section shall not apply to the issuance of orders pursuant to 11.21 of New York City Health Code. And so that is another piece of legislation. I'm not going to read that. If you are interested in reading that, then do look that up yourself. In addition to the removal of detention orders referred to in a subdivision 2 of this section, and without affecting or limiting any other authority that the commissioner may otherwise have, the governor or his or her delegee may, in his or her discretion, issue and seek enforcement of any other orders that he or she determines are necessary or appropriate to prevent dissemination or transmission of contagious disease or other illness that may pose a threat to public health, including, but not limited to, orders requiring any person or persons who are not in the custody of the department to be excluded, to remain isolated or quarantined at home or at a premises of such person's choice that is acceptable to the department, and other such conditions for such period as will prevent transmission of the contagious disease or other illness. Now, before I continue this reading this long-winded sentence, now this is why most people don't like law, is because it's long-winded sentences. They require an active memory, better short-term memory skills, right, and patience. But these are skills that you can work on. Sure, you may not have a lot of patience now, but take your time reading through things like law. It will help you to improve your patience by taking the time and reading all the way through things. And reading long sentences like this does help with short-term memory. Right? Your brain is a muscle. If you don't use it, it atrophies effectively. Okay, so continue reading, and hopefully you've remembered everything I've said so far, or at least, now here's the other thing. When you are reading long sentences, right, these long sentences, don't focus so much on the individual words on your first read through. Right? When you're reading the law, you want to read through it a couple of times, but the first time you read through, you want to get the gist. So instead of trying to pick out words, read the words and let little ideas form into your head, and let those little ideas start to little extra ideas tack on to build a bigger idea. And again, this is something that you need practice with. But for now, to continue reading. To require the testing or medical examination of persons who may have been exposed to or infected by a contagious disease, or whom may have been exposed to or contaminated with a dangerous amounts of radioactive materials or toxic chemicals. To require an individual who has been exposed to or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventive medication, or vaccination, including directly observed therapy to treat the disease and follow infection control provisions for the disease, or to require an individual who has been contaminated with dangerous amounts of radioactive materials or toxic chemicals, such that said individual may present a danger to others, to undergo decontamination procedures deemed necessary by the department. Okay, so let's talk about what's good here, what is well written here, okay, and as well as some things that could present problem. So the governor in his or her discretion. Okay, so this is basically saying, do they feel like it? And this is telling you not only do they have to have the evidence to do so, but they need the desire. Right? It's not compelling the governor to do anything. So it talks here about being limited at home. Okay, so this would allow for the lockdown orders that have been going on, many of which have turned out to be unconstitutional by either state constitutions or federal constitutions. So that's one thing that this part does. Now, this part by this talking about radiation is interesting, and the problem here is that, again, the text is subjective. Now, this is a problem when we're talking about radiation, because because radiation does not inherently mean someone will get sick or something bad will happen to somebody. You're talking about a person exposed to radiation gets to it becomes a statistics game, okay, based on the amount of radiation in RADS or REM or whatever. I can't remember what they're using now. Okay, so by the amount of radiation that a person has received. Now, as I said in another video, you get radiation from everything. You're getting radiation from your screen right now. You're getting radiation from the sound of my voice, the heat, the sun. But these do not. Forms of radiation will not make you a threat to other people. The body actually naturally produces radiation because it's just something that happens, right? Also, like radon, right? Radon is a natural occurring element. When it degrades, it's particulate offspring daughters, as we used to call them. I realize, I understand they changed the word. I don't fucking care. I'm still going to call them daughters. They become airborne particulates. They can go into your lungs, and that's why you test homes for radon and so forth. But this text here, contaminated with dangerous amounts of radioactive materials that may present a danger to others. This again is highly subjective text and is very and presents a large problem. In order for this to have any kind of now, if I were to say, okay, we're gonna go with this part again. Well, I would want numbers. What kind of numbers? What radiation from the person would be required to be considered dangerous, right? So you can absorb radiation, right? And all radiation is depositing into its energy and transference from one to another, or one place to another, right? So you have your heater going. Your heater is radiating heat. It gets absorbed. That heat energy gets absorbed into your skin and warms you up. All right, and warms up your body. So the same thing when we're talking about gamma, photons, right? So the light coming from your screen, that's photons. Gamma, X-rays, that's all different energy level photons, higher energy levels. And for those of you that are physics students, you have your 3 ways that photons interact with matter. And a little memory aid I learned a while back is that photons pee, they cuss, and they pee some more. So hopefully that'll help you remember. P, they interact through photoelectric effect, Compton scattering, that's why they cuss. And then they pee some more, that's your pair production. So you're welcome, physics students. But yes, when we're talking about a person putting out radiation, like I said, a person's body naturally emanates radiation. So we need to have specific levels in this legislation. Otherwise, it's just a subjective document. But you can absorb radiation, right? So typically with gamma radiation, you have photon-based radiation. You'll just absorb the radiation, and that's it. Other forms of radiation, you have neutron radiation, alpha radiation, beta particle radiation. Those are pretty much your main types of radiation. But for the most part, it'll just deposit the energy into your body, and that those particulate forms of radiation will just turn into heat in your body at the cellular and chemical level. So that energy will break bonds. Typically, that's basically what winds up happening as a result of radiation. Bonds in different chemical strains in your body start to break down because all that heat energy, things move around faster, right? So now that doesn't necessarily mean that you generate more radioactive particles in your body. Okay, so for you to emanate radiation after being exposed to radiation, that's some ungodly high levels. So, like, amount of levels where you're probably going to die in a couple hours. So, yeah, fun stuff to think about. But anyways, we'll continue reading. Such person or persons shall, upon request, be afforded an opportunity to be heard, but the provisions of subdivisions 2 through 11 of this section shall not otherwise apply. Okay? The provisions of this section shall be construed to permit or require the forcible administration of any medication without a prior court order. Okay, now this is something that pretty much exists because of the Jacobson Supreme Court decision. And that's all stuff. So this old text, the bold text here, was to be added into the health code. And this last little part here is back of the original act. So section 2, this act shall take effect on the 30th day after it shall have become a law, effective immediately by the addition, amendment, and or repeal of any rule or regulation necessary for the implementation of this act on its effective date are authorized to be made and completed on or before such date. Okay, so that's just saying, when everything takes effect. So now, opinions. All right, and you can see they have a little comment section. No, comments. Okay, not a comment section, but they have the little, do you support this bill, and so forth. And, oh, there we go, comments. So you can put your name, email, and, tell them what you think. So, what do I think of this legislation? Well, I'm not a fan of Jacobson. And this is something that I've talked before in other venues, but I understand the intent to not want to spread communicable diseases, or to want to prevent them from spreading. But there is the case to be made that wanting to take action only just makes you feel better, because by taking action you feel like you've done something, you've attempted to take control of the situation. When children are born, they breastfeed. After a short while, they stop breastfeeding. Why? Because breastfeeding gives them antibodies, gives babies antibodies from their mothers. This allows children to start building up their own antibodies. And they start getting exposed to different pathogens. And there is something to that old George Carlin line of wanting to give your immune system practice. And it becomes that what's it called? That idea of like a benevolentism versus a malevolentism, right? Where a benevolentism is more harmful in the long run, because now you've taken away a person's ability to be self-sufficient. And one thing that you'll understand if you study all the different branches of sciences like I have is that truths in human behavior, in some really weird way, also show to be truths in the way that the science and nature work. So sure, we can protect ourselves from diseases, but if we protect ourselves from diseases and not allow our bodies to fight back against them, well, our bodies do lose practice, right? It's just kind of a natural thing. And I'm not talking strictly in the case over one person's life, but in multiple persons' life. Now, of course, this may sound cruel to a lot of people, but the decision is made. Do you want to save some people now to risk losing more people later? Or do you want to risk losing some people now to potentially have more people survive later? Things in life are not such easy decisions. Personally, I would have to go against this bill. Now, I'm pretty sure that there are a lot of people with good intentions that want to believe that they're doing the right thing. But unfortunately, when we talk about science and an explanation I just gave to you, sometimes it's not necessarily what you think is the right thing now is not necessarily the right thing in the long run. Now, you may have a different idea. That's fine. Because after all, there's no such thing as a set future. It's all a numbers game. It's all a gamble. But in my opinion, we should take the gamble, or we should make our choices on what to gamble on wisely. And I don't know about you, but personally, I've always been in the practice of going through the hardship now so that later on any similar situation becomes easier. Potentially. I mean, you never know. An asteroid could strike. You can't prepare for that. So that is the reading of this assembly bill. If you have any thoughts and comments, especially if you live in New York, I mean, if you live in New York, you definitely want to express your thoughts and comments to your legislators. But if you've been listening all the way through this video, then hopefully you've come out a little wiser. And I suggest you ruminate on everything that we've talked about. Maybe read the legislation yourself. But that's it from me.